I say the process starts, that was in the context of reference. And what is just a minute, I'm sorry. My lords, my friend has proved for us, my lord, it has been written in 3 parts, A, B, C. My friend has argued expectation. That is nothing like in, I have said, my lord, yesterday also, the applicant has no right at all. Even your lordship, right from constitution, Sankarsan Das said, even the selectee doesn't have it. And that has been reiterated in this term. Says expectancy, etc. No, there was no promise that I will not amend them. That it is a discretion. Executive has taken a council decision. Now, all the paras have marked, my lord, are relevant. Finally, conclusion, it starts from the issuance of the petition. I have marked, my lord, with brother Lord Tracy, and he also said, I have marked with 1, 12, 22 to 27, 59, 51, all these judgments, my lord, will have apart will follow. And this judgment we read to nothing, no cause, except to my lord, I wrote a rampart. What is indicative strategy? I got illustration and some examples from the slides by the paper. Since your lordship, it was in the context of my lord, UPSC, start, and indicative advertisement means indicative advertisement that the vacancies mentioned are only indicative. My lords have already said, and then my lord will kindly see. It was, there are a number of, my lord, this indicative notice available on site. I quote, for example, it pertains to indicative notice, my lord, of 2025. It says, my lord, bound of 2025, Union Public Service Commission. Then, my lord, it was of the Implied Provident Fund Commissioner. Then it later, my lord, why it was, and the last is, my lord, like a similar way, one page. I have not seen any advertisement of PSC in one page except indicative. Because we don't, and that I have this, so we get the indicative recruitment as special advertisement. Only difference is this indicative is not mentioned. My friend is referring to a gentleman that is not mentioned. But it doesn't mean, none mentioning, if the things are clear and per law, mentioning, none mentioning of any word that will not invalidate them, but will not sit. So this is the indicative notice of the UPSC in service to students. And my lords, particularly in recruitment process, it is a well-known fact that why it is given, because it is, if you are going to, I am as a recruiter always want the best one. If some so that a person is make itself ready, documents, etc., start preparation. And my lord, he was arguing of ITI. So ITI will be absorbed in, they may not have aspired that our engagement in employment only in the railway. Railway do not say you are studying ITI and we will absorb. We have a policy apprentice, etc. This is possible. No. But you are eligible. Otherwise, though there is no application, they are eligible. Why they don't have to go or compete? I can, my lord, all graduates appear in that UPSC selection. MA भी आता है, IITN भी आता है, डॉक्टर भी आता है, लेकिन जो क्वालिफाई करता है वो नौकरी मिलती. The aim is to have the best, intelligent. This is the very purpose of employment to direct process. This is not the case. If you are a promotee, if you want to go ahead, that is a different thing. I cannot, my lord, in the morning, I recollect your leadership, so the council was not arguing in the context of the rule. There was a case I was sitting. The lordship pointed to council, unless you have got the appointment, basis of existence, there is a sudden change in that would affect the case, then I may have a case. Again, your lordship pointed out. I think council did not get it. But nobody was arguing lordship. This I know it. And my lord pointed, yes, if any change suddenly, basis of which I joined the department and the empire, and it is changed introduced to my interest, that I have a case of arbitration. But there is a case. Altogether new appointment, direct recruitment. Tomorrow, an engineer, doctor will start saying, look, I am the doctor, I am the engineer. Where is the question of a graduate being appointed as civil servant? It's lordship, you say, executive. What lordship? So my lord, one line off. Not one. This is the case. I humbly pray that it should be dismissed with a cost. There are ordered one more. My friend has forced me. Fabulous petitions and all. Normally I don't argue. But my friend's conduct, we have been appearing in 1-2 cases. They start saying, he starts teaching me sometimes being quite younger. My kids are more than his age. And I have the practice at part more than his age. So, in a similar PI, I will not take. I will not sit. I will give a copy to my. I will not take. I will not take. The lordship may say, what the High Court says. I restrain my lord, but I have an objection. This petition was filed and this was argued, and because of the internet connectivity, my arguments could not have been heard by the Honorable Justice. Therefore, 1 lakh rupees was imposed. That has been waived. That has been waived next week. My lord, this is not relevant at all. My lord, this is very much. No, I did not argue. I did not argue with certain conditions. Last one. I insist on it. With condition. I tender apology before your lordship. Your lordship, pardon me, doesn't mean, my lord, even a probationer is a criminal is acquitted by the court. My friend should also apply this code. That the Honorable Supreme Court on my petition of introducing a forensic science investigation in criminal law. That is, we don't argue my petition itself. We don't argue. My friend is showing this, that also must be changed. No. That those changes have been made on my petition, on my lord, I think, but this is not the case of criminal. I did not. So far, my friend has argued 2 hours, 1 hour, but it's not able to prove that this 28th of December is not an advertisement. It's an advertisement, not an advertisement. My lords.
Mr. Sinha, I think.
मैं लोग one saying ना, ये मैं ये भी कहा था कि हमारा 2 तारीख वाला एडवर्टाइजमेंट हमने पब्लिश किया, इनको भी बता देता हूँ.
हाँ, that was published. That he is not denying. That's why they have approached. Now, I think what you need to but yes.
Well, I'm told to
First, no. Main aspect is that you are aware that in the tribunal, under the ATS, under the rules of practice, you have to file the original application in a particular format.
Yes.
So that format requires that there should be a verification at the end of paragraph 12. So there is no verification. When the affidavit which is attached cannot substitute. This is his argument. What do you have to answer to that?
But I will argue all those preliminary objections which has raised by my friend with the judgment of the Supreme Court in the context of the Supreme Court. So far, what I am just saying that my friend has argued merit as well.
So yes, he has said that it was an indicative.
Yes, I'm coming on that. I'm coming on that. Before that, works, I just want to give a document for us. The friend has argued this all the before of the
I don't know. I could do not.
Okay. First works comes from 28th of December. Page number 26 of the OS. And before that, I have filed the miscellaneous application for amendment of 25 to 24. In the prayer note, we have written CEN 8/25. So this is CEN 8/24. So not if I filed the application for amendment of that word mallet that whole schedule 25 to 24.
It is already 24.
That is there. That is even headings also there are 24. Now, page 26. Page 26. This is Government of India, Ministry of Health. Again, I am reiterating that name of the post. Name of the post, various posts in level 1 of the 7th CPC payment. Initial pay rupees 18,000. Now come to the very important, the post-wise educational qualification and medical status. Post-wise educational qualification is clearly intended that there are various posts and qualifications to be different. Now come to that. Para 7, which is recruitment process. For details, please refer para 14 of the details. Now the question is, they have issued on 28th of December 2020. How a candidate will find where is para 14? And number 2,
It says in para 1 itself that there will be detailed CEN.
Yes.
And it says in first para the detailed CEN will be uploaded and link will be
Correct. Now the very prima facie contention is that this recruitment, the name of this recruitment comes Centralized Employment Notification number 8 of 2024. And they have changed the policy on 2nd of January 25. Now the question is, applications are invited from eligible candidates for various posts in level 1. And the same they have written in the main advertisement, which has been issued 22nd of January, that date of indicative notice. Now, my lord, when what these Pathak judgment also says, and same as argued, settled the principle of law, and my friend is saying that this letter of 28th of December is not an advertisement. So, my lord, what I am saying, if it is not an advertisement, then what is it? And if my friend is saying that qualifications are not mentioned in that letter, qualification will be given on when the application will be open. That is okay. Now, if somebody wants to apply for this advertisement on 30th of December 2024, how will he come to going to find that what qualification would be there on 30th?
He will have to wait for the detailed CEN because in any case,
that means
30th of December is not the date of application. It says this notice says opening date of application is 23rd January.
Date of application 20.
He in any case cannot apply on 30th December.
Date is 22nd of January is the date of application. Now, if the qualifications were not there in the 28th of December letter, that means that the qualifications which were existing on that date will prevail. And I can support in the judgment various, but my friend has so far not shown anything that this is not done. 2nd January they have changed. They have issued the advertisement 28th of December.
My lord,
and
I have curtailed my
from this point,
I have curtailed my argument before your lordship. I could have taken another 1 hour and 2 hours for such text, not for satisfaction of my friend. I have shown number of judgments, but he is not arguing, replying the preliminary objection.
He said he will.
No.
I said,
Basic.
No, I am not going to leave him without his answer.
No, my lord, the basic, the basic law is to meet the preliminary objection,
First.
then proceed. Now, I
Young lawyers,
last time भी मैंने इसीलिए नहीं किया. I respected my friends' moods, and therefore I did not.
No, he.
Otherwise, I have a right to raise first and object that.
So you come on preliminary. You think we get your.
My lord, I am taking.
that is the
My lord,
beginning of
yeah, my lord, I am just taking this.
You can talk.
my contention is that if my friend would be able to prove that till 22nd of till 28th of December, on the date of 28th of December, if any document they will prove that the qualification which have advertised publicly, that will be only 10th plus, 10th pass, then my lord will satisfy that okay. But so far there is nothing as such, and even the this transcript, so somebody has, I am also giving the certificate of electronic record that this transcript have been made on the proceeding of the High Court. I have answered liya nahi ho sakta. For which, yes, for what purpose? For the purpose.
When you challenge the interim order.
No. Yes, for that. When the yes.
See what is the value of that? Because we have the order with us.
That is that order is there.
The order is by the trial.
Order is there, and again I am coming on that law that my rejoinder page number 12. Again, for a moment, page number 12. The only question is again that whether as the advertisement was issued on 28th of December. My friend have argued that this is not an advertisement, but the court has rejected at first that this is an advertisement. Now you please answer that how can you change in this advertisement? So this is advertisement, my again contention.
But that question has been left open for the tribunal to decide.
Yes.
So then that question entails in itself questions of maintainability of your OA itself.
Correct. So address that point.
And that question also entails their right to argue that this 28th December notice is only an indicative notice and it's not an advertisement. So you are trying, so you have to do a twin job. First, to come clean on your maintainability, and second, of course, that is the main argument of merit between indicative notice and an advertisement.
I just say that whatever preliminary objection have been raised, अगर मुझे written में देते, I will answer for each other. बताओ ना. Because so far 11th month have been passed from the date when the OA, and now they are raising this technical.
नहीं, उसमें से ये भी है ना कि the representations are not by the.
One of the applicant is there.
Then why have you said that the applicant's representation are next at this page, whereas there is some other person has signed that? Isn't that a playing of God?
What happened? I'm telling you, the issue pertains to all India recruitment. Therefore, various across the country students are filed the representative, and one of the applicants, I will give on record. I will give that this person has given the representative. He signs. मैं उस पे रिटर्न में भी दूँ, तो वो ऑब्जेक्शन में जितने किए I will answer in the written में, तब मैं रिटर्न में आंसर करूँगा, because only it's not permissible. Only what is today is what this case is. What my friend is again and again reiterating that this is a fraud, this is a fraud, this is a fraud. The question: what fraud and how you have deceived with my fraud? If I have not signed, made the verification, how you are going to affect it? How you have affected it? You have not affected. Your facts are very clear. My facts are there on record. Advertisement I have placed. Readings.
Alright, who are you? That will be identified by the verification only.
That is good. I know. Affidavit to दिया वो
डेबिट ही नहीं मैं कह रहा हूँ. अभी जो
It is not fixed.
बब्बू कौन है, नीरज कौन है, कौन है ये राजेश कुमार कौन है?
हाँ, मेमो पार्टीज और
इनका रिप्रेजेंटेशन तो है ही नहीं.
एक का है
किसका बताओ? किसी का ही जो आपने लगाया उसको नहीं. गौरव का है, ये है बाजारी का तो
उसका नहीं है.
आपका तो नहीं है, वो तो नाम ही गिनती है.
चार ही लोग हैं.
आप तो चारों में किसी का
मैंने तो देखा मैं बहुत सारे डॉक्यूमेंट्स जिसमें तो टाइम
तो आपने हुए तो
मैं कल रिटर्न में आंसर कर दूँ किस व्यक्ति का यहाँ पे रिकॉर्ड है. आई विल आंसर. Because it will take time.
ये रिप्रेजेंटेशन की बात को पेज की डेट क्यों उठा दी?
निरंजन कुमार, बबलू, मनीष कुमार, राजेश कुमार, इनमें से किसी का नहीं
है.
एफिडेविट कहाँ साइन किया?
और ये नहीं, मैंने रिप्लाई कब का फाइल किया है, हाईकोर्ट में भी किया है। उन्होंने आज अमेंडमेंट की बात इससे आपको लिस्टेड नहीं है, लास्ट में जो हमें अमेंड करो, स्टेजेस आई कैन आर्गू ऑन दैट ऑल्सो, बट
Lord, I have come up with a fine petition on this, that whether amendment could be allowed at this stage or not. I have that.
Yes, मेरा आपको प्रश्न श्रीकांत ये भी है कि इस होए में आपका कहीं पे राइट वायलेट हुआ है, अंडरमाइन हुआ है?
Yes, sir.
आपको आप परीक्षा दीजिए,
उसकी रेफरेंस में भी I have the judgment.
आप परीक्षा दीजिए, आपको तो इसमें डिप्राइव नहीं किया गया।
If I will,
अगर आपको डिप्राइव किया होता तो आपका लोकल स्टैंडर्ड होता।
if I will appear in the examination.
1,08,00,000
1 करोड़
परीक्षा
8 लाख
लोगों ने भरा है, तो आप ही कंप्लीट कीजिए ना, और आप तो ज्यादा क्वालिफाइड हैं।
Now,
आप ITI पास हैं, NCA पास हैं।
questions will be of 10th level, my lords. It's not a level playing field, my lords.
लेवल प्लेइंग फील्ड, आपको you are more than the higher level playing field.
Once the qualification has been like my question, I totally agree with that, but I'm totally agree with that. My friend has said that they are the sole authority body to frame the policy. I admit, yes, correct. But my main case is that their advertisement is issued on 28th of December. They have changed on 2nd of January. So the qualifications which were existing, that is applicable. That is one line. अगर preliminary पे मैं फाइल कर दूँगा ये first one amendment application का not sooner there because that is it's listed my lord today. But it's today listed.
Once it was quarters, listing case was strange.
It is listed.
चलिए ठीक है।
only my one thing is it, your lordship decide either way. But on both my preliminary objections
Yes.
and then as a query. But the reasons, my lord, if it is decided, I know it will go to, I need that it will go through to decide. I'm careful, my lord.
But amendment application is listed for today. Kindly have a on the on this ma'am. That is there.
Once the matter has proceeded for final hearing,
But-
on your insistence that there is urgency, in midway, once they have opened their cards and raised all the objections, there is no procedure for to file an
That is
amendment.
there. Amendment can be allowed at any stage before pronouncement of judgment, my lord. That is what 5 judges ban Supreme Court saying, my lord.
Yeah,
There is nothing. There is nothing.
Even this order 6 rule 17 says
27 says.
that there is some नहीं पढ़ा हूँ
Amendment पे भी एक बार
ऑर्डर रिजर्व है।
I'm grateful for patience hearing.
ऑडियो पार्ट हो गया है।